My name is Paul Vallone. You are listening to the Big Talker Network at bigtalker.live. I'd like to welcome you to Guns, Politics, and Freedom, where each Saturday at 1 p.m., Sunday at 5 p.m., and weekdays at 11 a.m., we give you the ammunition to better defend your gun rights. I'd also like to thank our sponsor, Hyatt Guns, America's largest gun shop. Check them out at hyattguns.com. In case you aren't familiar with me, I direct Grassroots North Carolina, or GRNC, since 1994, our state's most effective gun rights organization. As its director, I was involved in drafting and passing our original concealed handgun law. Since then, GRNC has gone on to engineer passage of concealed handgun reciprocity, our purchase permit bypass, Castle Doctrine and Stand Your Ground, the expansion of concealed carry into state and municipal parks, restaurants, public assemblies, educational properties, and much more. Grassroots North Carolina is exactly what the name implies, a grassroots collection of volunteers from all walks of life who share a common concern that our constitutionally guaranteed freedoms are being eroded. Check us out at grnc.org. That's grnc.org. Gun rights supporters often ignore judicial elections, assuming they are not relevant to defending the Second Amendment. But that assumption is wrong. In recent weeks, for example, our Democrat-controlled North Carolina Supreme Court just overturned congressional districts drawn by the Republican General Assembly, and in so doing neatly cost Republicans 2 congressional seats in the next election by imposing districts which are essentially 7 Republicans and 7 Democrats. This, by the way, after an en banc hearing of all 15 judges on the Court of Appeals had approved those districts. You see, who wins elections depends largely on how political districts are drawn, and leftists, understanding that, are now busily trying to sue or otherwise manipulate political races to ensure themselves a permanent lock on power. And if that happens, you can expect big infringements on your Second Amendment freedoms. So in the second and third segment of today's show, we have as our guest Court of Appeals Judge Richard Dietz, who is running for the North Carolina Supreme Court. You see, right now, Democrats hold 4 of the 7 seats on the Supreme Court, but 2 of those seats are up for re-election, and one of them is an open seat previously held by retiring Democrat Robin Hudson. And if Judge Dietz, who is a strong originalist and conservative, can win that seat, conservatives gain control of the court. More on that later in today's show. Also important today is the big event being held next weekend on April 9th, when you can make your voice heard and defend the Second Amendment. April 9th is the day of the Grassroots North Carolina Ring Steel for Freedom event. This is a steel plate match for handgun and rimfire rifle, and also a barbecue at which you can make your voice heard as you meet and greet major candidates in the 2022 elections, including Congressman Ted Budd, who is running for the U.S. Senate, specifically with the seat being vacated by retiring Senator Richard Burr. Budd is a gun owner, whom it is safe to say is the most pro-Second Amendment candidate in the field of candidates vying for the Republican nomination. Then we have Lieutenant Governor Mark Robinson, who may be our next governor, and whose meteoric rise began when a video of his passionate defense of gun rights to the Greensboro City Council went viral. He will be joining us as well. Also joining us will be another gun rights stalwart, Congressman Dan Bishop, as well as Judge Dietz, Court of Appeals candidate Michael Stadding, and other candidates. And last but not least, we also have Eric Pratt, who directs Gun Owners of America, our nation's most effective gun rights organization. This event will be held at the new and very classy Hyatt Farms shooting complex in Polkton, North Carolina, about an hour east of Charlotte. And no, you don't have to be an experienced handgun competitor to shoot the steel plate match. Beginners are welcome, and you don't even have to bring a firearm, since both firearms and ammunition will be available from Hyatt Farms. And if you don't want to shoot the match, you can buy a ticket for just the barbecue and the meet and greet with candidates, which begins at 11:30 that day. The event is being held to raise money for our Political Action Committee, the GRNC Political Victory Fund, in order to elect pro-gun candidates in the 2022 elections. That's April 9th at Hyatt Farms in Polkton, with registration beginning at 10:30 and the barbecue beginning at 11:30. For tickets and information, go to grnc.org. That's grnc.org. Elsewhere in gun rights news, under the Biden administration, the Bureau of Alcohol, Tobacco, Firearms, and Explosives is added again. Remember those ads that used to run for Girls Gone Wild? Well, we can call this ATF Gone Wild. In the last episode of Guns, Politics, and Freedom, we discussed the alarming fact that the ATF had just responded to a congressional FOIA request by admitting that they have now amassed no less than 920 million firearms transaction records. Yes, that's nearly 1 billion records. Worse, the number has tripled since 2016, when the ATF professed to have only 285 million records. Now, you may recall that under both the 1994 Brady Act and the 1986 Firearms Owners Protection Act, the ATF is prohibited from creating a national gun registry, and may legally acquire transaction records from Form 4473s only when a gun dealer goes out of business. So the question becomes, is that the only way they can acquire records? If that's the only way they can acquire records, how did they get 700 million records in just 5 years? You may also recall that 51 congressional Republicans wrote a letter to the ATF asking just that question. And then among those Republicans were our own Congressman Ted Budd, who is running to replace Richard Burr in the U.S. Senate, and Congressman Madison Cawthorn. Well, now 41 congressional Republicans have gone a step further and filed legislation, specifically H.R. 6945, which is titled the No Registry Rights Act. The bill is sponsored by Texas Republican Michael Cloud, and according to the Carolina Journal, a publication of the John Locke Foundation, I'm happy to say that among its 40 co-sponsors are our own representatives Dan Bishop of the 9th District, Ted Budd of the 13th District, and Madison Cawthorn of the 11th, and finally Richard Hudson of the 8th District. That's the good news. The bad news is that in Nancy Pelosi's House of Representatives, the bill almost certainly will die for lack of a hearing. More on this as it develops. And speaking of the ATF gone wild, I'm afraid illegal gun registration isn't all they're up to. If one wants to build a Title II weapon regulated by the 1934 National Firearms Act, such as a short-barreled rifle or a sound suppressor, one has to first file a Form 1 application to make that firearm. Well, according to AmmoLand.com, now it seems that the ATF is blocking applications for homemade suppressors. Specifically, it blocked fully 3,000 such applications, including 850 which it denied and then sent to field offices for potential prosecution for what could be a 10-year federal felony. At issue is a secret rule change on 80% kits used by people to build legal, registered suppressors, in which the ATF goes fishing for large amounts of detailed information in an apparent attempt to trip up lawful gun owners and set them up for prosecution. In a similar vein, the ATF has now declared solvent traps to be sound suppressors. Solvent traps are devices used when cleaning firearms to catch the cleaning solution if poured down the barrel. Solvent traps can be manufactured into suppressors, but that doesn't mean that they by themselves are suppressors. So in this secret rule change, the ATF is now threatening to prosecute anyone who files a Form 1 to turn one of these solvent traps into a suppressor, all in an apparent attempt to harass gun owners. Elsewhere, in mid-March, the NRA reported that, at the direction of the Biden administration, the Bureau of Alcohol, Tobacco, Firearms, and Explosives appears to be revoking the licenses of firearms dealers for even minor paperwork violations. At issue is a June 23, 2021, announcement by the administration of a new policy of, quote, zero tolerance for rogue gun dealers that willfully violate the law, end quote. The policy further specified that, quote, absent extraordinary circumstances that would need to be justified to the director, ATF will seek to revoke the licenses of dealers for the first time that they violate federal law for certain specified violations. According to Lee Williams, writing at AmmoLand.com, that is part of Biden's false narrative that rogue gun dealers, rather than leftist policies, are responsible for skyrocketing gun crime. A FOIA request made 9 months ago by the Second Amendment Foundation's Investigative Journalism Project for statistics that could either prove or disprove Biden's claim of rogue gun dealers remains unanswered by the ATF. More on this as it develops. Right now, you're listening to Guns, Politics, and Freedom on the Big Talker Network at bigtalker.live. After a short break, we will return with Judge Richard Dietz and our discussion of why judicial elections are critical to gun rights. My name is Paul Vallone. You are listening to Guns, Politics, and Freedom today on the Big Talker Network at bigtalker.live. Our show is sponsored by Hyatt Guns, America's largest gun shop. Check them out at hyattguns.com. We are fortunate to have as our guest today Judge Richard Dietz, who currently serves as a judge on the North Carolina Court of Appeals and is a candidate for North Carolina Supreme Court. Judge Dietz, welcome to Guns, Politics, and Freedom.
Thank you, and thanks for having me on the show. I'm excited to talk to you today.
Well, personally, I don't think gun rights supporters pay enough attention to judicial races, which are actually vital to defending the Second Amendment. We'll talk more about that in detail, but before we get down to that particular business, why don't you tell us why you are running for the North Carolina Supreme Court and what makes you uniquely suited for the position?
Sure, happy to do that. And let me start by saying you're absolutely right, and this is a big part of my messaging is I know your listeners are far more informed than the average voter, and even they probably don't know that much about what's going on in our state courts. And, we're down there by the dog catcher on the ballot. It can be hard to know what's going on in the court system, and I see this every day. So, just like many high-ranking state officials, they give us a license plate from the state. So I drive around in a car with a state seal on it. It says Court of Appeals and then number 3 because I'm third in seniority on the court right now. Mm-hmm. And, that means at the gas station, folks will sometimes come up to me, they'll look at me like, Court of Appeals, you some kind of judge? And, I'll say yes. And then they'll start telling me about their traffic ticket or their divorce or something like that. And, I have to say, my friend, I'm not allowed to talk to you about your case, but also you should understand if your traffic ticket's in the North Carolina Court of Appeals, something has gone horribly wrong for you. That's not what we do. Did you murder somebody at this traffic stop? That sort of thing. But it helps me see that there is a lot of information that folks should know about our courts, and it's just people are busy during their day, and the courts are just not a priority. And so I've made that a big part of my campaign. So I'll tell you a little bit about my background. Before I joined the Court of Appeals 8 years ago, I was an appellate lawyer, and Paul, as you know, because this is part of how I met you, I did a lot of constitutional litigation, and that's something that most lawyers, they might have an interest in the Constitution, but they're not actually doing the work. They're doing family law or criminal law or that sort of thing. But I spent a lot of time with free speech cases, and so these were First Amendment cases, sometimes student speech, because as you know, the rights of students right now to be able to speak about their views in the classroom is something that's very controversial. So I was defending students that wanted to speak. And I've also done some other cases, including I know one of the ways I've met you initially was working on a U.S. Supreme Court case. So I'm one of the few lawyers in North Carolina who stood in the U.S. Supreme Court and argued cases. The biggest one of my career was a case about gun owner rights. It wasn't a Second Amendment case, but it was a case that had the involvement. I had the support of a lot of groups that defend the Second Amendment and the rights of gun owners, and I was advocating for someone that I really thought was being railroaded by the Obama administration at the time. And so, I understand the sorts of things that your listeners see going on in the courts, and I think my view of this is I just need to get the message out so people understand I'm a solid judicial conservative who understands what's the role of a judge. Defending the Constitution it's protecting the rule of law, and it's not legislating from the bench. And unfortunately, I think we're seeing more and more judges moving into the court system who don't share those views, who have a much more progressive view of what's going on in our courts.
I would say that it's not really progressive. I've stopped using that word entirely. I replaced it with leftist, because progressives are anything but progressive. 9 times out of 10, they're autocrats, and they adopted that particular moniker, I believe, to make you look regressive. But that's just me. I could be wrong. All right, so we have 2 Supreme Court seats that are up right now, and 4 Court of Appeal seats that are open in the 2022 elections. In your opinion, what's at stake in the 2022 elections in North Carolina, and for that matter, in other purple states?
Yeah, so this is the big one, and here's why. So there is a liberal majority on our state Supreme Court right now. So there's 7 justices on the state Supreme Court. That's something that sometimes confuses people because, of course, there are 9 justices on the U.S. Supreme Court. There's only 7 in North Carolina. And there are 4 Democrats right now and 3 Republicans, and those 4 Democrats have a very liberal judicial ideology, in my view. But here's what's important. 2 of those Democrats, their seats are on the ballot. And one of them, the seat that I'm running for, the justice there now is too old to run again. And so she's retiring. It's an open seat. So I've filed for that seat, and I'm now the Republican nominee, so I don't have a primary opponent. I'll be on the ballot in November, and that means if I prevail in that election, I'll join 3 other judicial conservatives and put the judicial conservatives in the majority on the court. So as you can imagine, that's made these Supreme Court races have national attention. As you said, in sort of a purple state like North Carolina, it's something that's bringing in folks from all over the country that have their eyes on this race.
So just to reemphasize, what is at stake here is control of the North Carolina Supreme Court that makes the decisions on a lot of very important things, not only to the Second Amendment, but to constitutional freedoms and a variety of other things. And so control of the court right now, it's controlled by the left, and this would be for control by conservative justices. Now, you've said that you don't have a primary election, but you're in seat 3, I believe. But there is a Republican primary for seat 5. Can you tell us a little about that race?
That's right. So, and this is something that folks really need to pay attention to, because we, in the last couple of cycles, in fact, going back for quite a while, there have not been, it's very uncommon to have Republican primaries in the judicial races. So folks need to understand you're going to see judges on the primary ballot this year. So in that seat, there are 3 candidates, and there is a candidate named Trey Allen. He is supported by our Chief Justice, Paul Newby, and he was a former law clerk for Justice Newby and is now the head lawyer for the court system. There is a judge on the Court of Appeals serving with me named April Wood, who was elected to the Court of Appeals in the last election in 2020. This is running for the Supreme Court. And then there's a 3rd candidate, Victoria Prince, and I'll just be honest with you, I don't know much about Victoria Prince. She is a lawyer, I believe, in Lexington, who I've never met.
Okay. Who it sounds like she doesn't have any particular qualifications. So Trey Allen is the candidate being supported by the Chief Justice. Is that a correct statement?
Yes, and a number of conservative members of the judiciary who are able to endorse. There are many rules that we have as judges about how politically active we can be, so you have to be careful in the words you use. So I'll give you an example is, because I'm a candidate now, I am allowed to endorse, and I have endorsed Trey Allen for that seat, but many judges who are not going to be on the ballot, they're not allowed to endorse, but they are allowed to say, this is somebody that, I have a lot of respect for and I've worked with and that sort of thing. So it's one thing I think that can sometimes frustrate voters and probably a lot of your listeners is they want to talk politics with judges, and there are just a lot of ethical rules for us that mean we can't talk about pending cases and things like that. So
I hear you. Actually, it's probably more frustrating for me than it is for them, because I have the task, if you will, of evaluating judges and trying to determine who we should recommend with our political action committee, the GRNC Political Victory Fund. We also run a super PAC we call the Judicial Fairness Project, and evaluating judicial candidates. Well, at one point in time, I believe judges in North Carolina were not allowed to fill out surveys. That's my recollection. Is that correct?
Yeah, so one of the criticisms that a lot of judges have about the system is that the rules seem to change over time, and it should be something where we know exactly what the rules are. But I think part of the reason that that slowly over time they've allowed judges to be more and more active is that we are elected officials. We are campaigning, and we need to be able to tell voters what our views are. So the rule now, that's the very strict one, is we're just not allowed to talk about pending cases or how we might rule. But when you're a candidate, you are able to talk more about your general views about, what's my approach to judging and that sort of thing, which I think is really important, because that's what people want to know is, what's the way that you're going to decide cases when you get up there to the high court. So I am glad I'm able to talk about that.
Right, but even then, there are particular things that I know judges will say, I really can't discuss that because if it comes up before my court, I may have to recuse myself, having previously expressed an opinion on that particular issue. Is that correct?
That's right, because that is one of the rules, is if you make those sorts of statements, yes, you can be required to then remove yourself from the case. The idea is there you've sort of signaled to the public that you already have a view, so you can't be impartial. And that's exactly why we're always so careful, because we don't want to be in that situation.
And that's frankly why we don't cover judges in our Remember November project, because that's an objective candidate evaluation system, and we have to use a survey and other stuff to objectively evaluate candidates. So we don't include them under the Remember November project, but we do make candidate recommendations with our political action committees. And in fact, Grassroots North Carolina is going to be very active in this judicial races this season because it's so important. Listen, I'm going to take a break right now, folks. You are listening to Guns, Politics, and Freedom on the Big Talker Network at bigtalker.live. After a short break, we will return with Judge Richard Dietz and the races this year for the North Carolina Supreme Court and Court of Appeals and what they mean to you. My name is Paul Ballone. You are listening to Guns, Politics, and Freedom today on the Big Talker Network at bigtalker.live. Our show is sponsored by Hyatt Guns, America's largest gun shop. Check them out at hyattguns.com. Our guest today is Judge Richard Dietz, and we are discussing the importance of judicial elections, both here in North Carolina and elsewhere. Judge Dietz, we've talked about the two Supreme Court races in which you and Trey Allen seem to me to be the standout conservative candidates. Now let's talk about the North Carolina Court of Appeals races. There are 4 open seats, I believe, in the Court of Appeals, or 4 races ongoing. Which candidates stand out for those races in your view, and what can you tell me about them?
Sure. So, yeah, again, this is something, and I feel, as I said, with judges, we sort of end up down there by the dog catcher at the bottom of the ballot. But at least with the Supreme Court, voters kind of hear that and think, well, that must be important. It's the Supreme Court. The Court of Appeals, now you're getting even further down the ballot. But the Court of Appeals is also very important. There are 15 judges on the Court of Appeals, and 4 of those 15 seats will be on the ballot. The court is currently composed of 10 Republicans and 5 Democrats. So there are 2 incumbent Republicans. That is the Chief Judge, Donna Stroud, and Judge John Tyson, a long-serving conservative judge. And then there are 2 seats that where one is an open seat, and then the other is a recent appointee of Governor Cooper, who's being challenged by a Republican. And those 2 seats are, the candidates are Julie Flood, who is a long-serving Court of Appeals, so sort of a lawyer that's been helping the judges for many, many years, and she's also a small business owner and was a professor of law. Very qualified candidate. And then Judge Michael Stadding, who is a district court judge, a member of the service, very good guy in my view, and he is running for the other seat. So I have endorsed both of those candidates. I think they're wonderful people. You will see some primaries in the Court of Appeals as well. So Chief Judge Donna Stroud has a challenger supported by many of the conservative judges in North Carolina named Beth Freshwater Smith. And Judge Smith is a district court judge in the Wilson and Rocky Mount area. So again, folks have got to pay attention to these because it's a lot to keep track of all the moving parts here. And but these 4 seats are very important because most cases are coming to the Supreme Court after moving through the Court of Appeals. So it's a very important court for our state and for our constitutional rights.
Well, I know in one of those, I guess it's seat 11, it's currently occupied by former State Senator Darren Jackson. And I know him. I've seen him operate many times. And he's a leftist of the first order. There's never been a gun he wouldn't ban. And so, or for that matter, a civil liberty he would not restrict, in my personal opinion. And so I think the seat 11 race is probably very, very important, from my perspective anyways. And so the standout candidate in that Republican primary to unseat Darren Jackson is Michael Statting. Would you agree?
Yeah, so I've endorsed Judge Statting as well. I have been campaigning with him for a very long time, over a year now. And I think he's just a fine guy. As I said, Air Force, done a fantastic job as a district court judge in the Charlotte area. So it's not easy to be a conservative in Mecklenburg County, but he's really shown he understands what it takes to be a good trial judge. I think he'd be a fantastic Court of Appeals judge. And yes, and you described that situation correct. So that's the seat when Justice Phil Berger Jr. became a Supreme Court justice in 2020. So you all elected him from the Court of Appeals to the Supreme Court, and that allowed Governor Cooper to make an appointment. And that is, as you said, Judge Darren Jackson, who has joined the Court of Appeals now, and he was formerly in the legislature.
Yes, and as I said, a devout leftist. I have seen this guy speak many times, and to say that he would be a judicial activist would probably be a significant understatement. So anyways, we have Flood, Stroud, Tyson, and Statting would be the standout candidates for the Court of Appeals. Okay, now let's talk about some of the dynamics of the North Carolina court system and how it's impacting our legislative representation, as various groups have engaged with some success, unfortunately, in litigation to overturn political districts and essentially overturn the will of voters who elected a Republican legislature to draw districts. What's going on there?
Yeah, so I have to be careful. The lawsuit's still pending, but I can give you a little bit of background about the case when it moved through the Court of Appeals, because we made some history at the Court of Appeals early on in the redistricting lawsuit, and that's because the Court of Appeals, where I am now, we typically sit in groups of 3 judges, so there's 15 of us, but we're only hearing cases 3 judges at a time. But there's a procedure that allows us to do something called sit en banc. It's all 15 of us at the same time. Mm-hmm. And in the redistricting case, a 3-judge panel of the court, and we don't disclose who are on those panels, but a panel of the court had issued a stay that stopped the candidate filing and sort of froze everything as this challenge was being brought up. And then the Court of Appeals, for the first time in history, sat en banc and reversed that, allowed the candidate filing to move forward. But then the Supreme Court took the case from us. And that's something that folks need to understand, is that in our state constitution, the Supreme Court, if it wants, can choose to have a case bypass the Court of Appeals. And that has become very common. It was a very unusual thing for many, many years. But these days, I feel like every week I'm seeing another case, another order entered where the Supreme Court has said, you know what, we'll just go ahead and take this case out of the Court of Appeals right now and take it ourselves. And so, this is part of what sometimes people ask me, what's the difference between a judicial liberal and a judicial conservative? And the way I try to describe it, and one of the reasons I decided to run for the Supreme Court, is that, for me, when people ask me what's the most important part of the Constitution, I tell them it's easy. I don't even need to think about it. It's the first 3 words. It's, literally the big words. It's we the people. And what concerns me is there's this growing trend of judges on the left who kind of see that as we the judges. They, this idea of the living Constitution, they're going to look at what they think that our constitutional rights ought to be, and I think that's dangerous. And so we need judges on the Supreme Court that understand the genius of our government is that nobody showed up and gave us our rights. We the people got together and created these rights for ourselves, and we need to honor that as judges. I think that's our most important job.
Yeah, here. Judicial restraint, if you will, holding to the original intention of the framers in drafting the Constitution, rather than, I guess, the judicial activists really are interested in reinterpreting the law to mean whatever they want it to mean. Would you agree?
Yes, I mean, you can see it, as you mentioned, you mentioned originalism. So with the Constitution, that's the idea we're looking at, the original meaning. What did we, the people, what are the rights that, we ratified, we put in our Constitution? It's also true, though, with ordinary laws. So I'm a textualist. So are other judicial conservatives. So we view what is the law when we interpret the law? Well, it's what the lawmakers said in the law. But there are many judicial liberals today who go beyond that, and they try to figure out, what do I think the law should be? And I just find that dangerous, because the reason that we elect our representatives in the legislature is that they're accountable to the people for the laws that they're enacting. And so those are the folks that should be in charge of writing the laws, and as judges, our job is to interpret it and to help people resolve their legal disputes. We are not lawmakers or policymakers, and I just think there are too many judges out there today that don't agree with that. They can't help themselves. They want to step into these policy or political arenas.
And you can't say this, but I can, so I'm going to, okay? It was the Democrat-controlled, for our listeners, it was the Democrat-controlled North Carolina Supreme Court, which just cost us 2 conservative congressional seats. Because I believe, as it was originally assigned, I believe it was 9 Republicans, 4 Democrats, and 1 swing district, I think. I could be wrong about that. But and then by the time they were done, basically it's 7 and 7. Because essentially they took away the power for redistricting on congressional seats and gave it to, what do they call them, special masters, was it?
That's right. So there was a 3-judge panel, and the 3-judge panel then appointed 3 what are called special masters. I know that's a strange name for people that aren't in the legal field, but that's what they're called. And those are sort of experts, professors, academics who specialize in these sorts of things. And then they in turn went out and got even more specialized experts, academics and things, to provide them with input. So it's sort of a strange system when the public understands what happened, because you think, well, aren't the judges the ones that are doing this? Why are they going to other people? But that's how the system worked, at least in this case.
And as a net result, essentially, they imposed districts on us for this election, and the Supreme Court refused, the United States Supreme Court refused to hear this for purposes of this election, although I understand the Republicans are going to eventually argue that case for future elections on whether or not these imposed districts are legitimate. Would that be fair? I mean, we're running out of time, so maybe a quick, do you think that's about right?
Yes, so the stay that was requested from the Supreme Court was denied, but you can always ask the court to hear a case, and my understanding is that has happened here. So there's a request for the U.S. Supreme Court to hear the case in full at a later time.
All righty, but right now we're still stuck with these districts for this election, and it will make a difference. Well, Judge Dietz, thank you very much for joining us. I wish you the best of luck in your race for the North Carolina Supreme Court. We need more people just like you.
Thank you, and thanks for having me on.
Folks, you are listening to Guns, Politics, and Freedom on the Big Talker Network at bigtalker.live. After a short break, we will return with still more information better enabling you to defend your gun rights. My name is Paul Vallone. You are listening to Guns, Politics, and Freedom today on the Big Talker Network at bigtalker.live. Our show is sponsored by Hyatt Guns, America's largest gun shop. Check them out at hyattguns.com. Have you heard about the battle going on in Florida? It seems that Mickey Mouse has gotten woke. Yep, Florida Governor Ron DeSantis recently signed into law House Bill 1557. That would be the law that gay rights activists are calling Don't Say Gay. But of course that's a lie. Nowhere in the law does it say that. And in fact, all the law does is to prohibit classroom instruction related to, quote, sexual orientation or gender identity up until the 3rd grade. It restricts it in higher grades only if it's in a manner that is not age-appropriate or developmentally appropriate. But the left is lying about the bill in order to better indoctrinate children. And Disney said in a statement that, quote, its goal as a company is for this law to be repealed by the legislature or struck down in the courts. And the company is, quote, committed to supporting organizations working to achieve that. And why did Disney issue such a statement? because they think it's appropriate to indoctrinate your children in kindergarten through the 3rd grade in a gay agenda, whether you approve or not. You know, I often talk about leftists and their impact on American politics, but leftist intolerance isn't confined to the political arena. Whether you realize it or not, you encounter it daily. A 2020 Cato Institute survey found that fully 62% of Americans were afraid to share their political views with others, up several percentage points from just 3 years prior. Most afflicted, of course, were conservatives, 77% of whom were afraid to share their beliefs. They have, in effect, become closet conservatives. Would we have felt that way even 20 years ago? Of course not. What you are seeing is the impact of constant leftist speech suppression. So thoroughly have leftist demands become inculcated into our culture that in the past 50-odd years, you might not even be aware of all the ways in which freedom of expression is being gradually strangled. Now, before extricating yourself from that stranglehold, you must first identify exactly when and where it occurs. Now, some of these examples might be familiar, others you might not fully realize. In the novel 1984, George Orwell created Newspeak, a fictional forced change of language intended to change thinking. But Newspeak is no longer fiction. As part of the effort to hijack your language, and by consequence your underlying thoughts, to conform with their political agenda, leftists routinely make additions to the long list of words and phrases we are prohibited from using. A friend recently asked what was wrong with the demand to remove plantation from our lexicon as racist. I replied, I don't give a damn about the word. What I care about is their motive, which is to control how you think. Attempts to brand your language as evidence of racism or microaggression have nothing to do with underlying topics and everything to do with silencing you and molding how both you and society regard the world. Bias in language extends to the ostensibly mainstream media, of course, which in recent decades has begun carefully inserting nuanced language into what purport to be objective news reports with the goal of changing public perception of events. Particularly virulent has been the spread of cancel culture, wherein most of the methods I'm about to describe are applied to public figures, corporations, and you to silence any with whom the left disagrees. The practice has become so extreme that even some on the left have referred to it as a reign of terror, particularly when it's levied against other leftists. I do love it when the left eats its own. The epithet racism is applied to both to silence mainstream Americans and to marginalize those who dare speak. Most recently, leftists have banned as racist not only illegal alien, but even benign words like master and blacklist. A Massachusetts appellate court is now refusing to use the word grandfathered due to supposedly racist origins. Other attempts to marginalize you as racist include claims of white privilege and the ever-expanding definition of white supremacy. Then we have accusations of microaggression, although theoretically defined as, and I quote, a term used for brief and commonplace daily verbal, behavioral, or environmental indignities, whether intentional or unintentional, that communicate hostile, derogatory, or negative, prejudicial slights and insults toward any group, particularly culturally marginalized groups. The term actually means anything a leftist finds objectionable at any time, and it's used to silence opposing opinions. Then there's media bias. Although overt bias is commonly acknowledged by conservatives and denied by leftists as fake news, media bias can be subtle enough to elude detection. In searching articles on media bias, for example, I came across one purporting to examine bias from both the left and the right. Yet it featured a section on reading for conservative bias with no corresponding section for reading on liberal bias. Or how about politically biased euphemisms? Sanctuary city, for example, is a euphemism for state and local defiance of federal law. Illegal aliens have become undocumented immigrants. The word homosexual has, of course, long been replaced with shifting acronyms wherein even LGBTQ is no longer adequate, having now been replaced with LGBTQIA, which, by the way, stands for lesbian, gay, bisexual, transgender, queer, or questioning, intersex, and asexual or allied. Or if even that isn't enough, they go to LGBTQIA+. And God help you if in a public forum you ever refer to the two genders, which got comedian Dave Chappelle canceled. Last year I started thinking, wouldn't it be great if I could find a book about how to defeat leftism in daily life? Because after all, most people don't know all the different ways they're being controlled by leftists. So I started looking for such a book. And you know what? I found books decrying leftism, treatises exposing Marxism, and calls to action, but I did not find one that had tactics required for such action. So I decided to write one. And the result is a book called Rules for Anti-Radicals, a practical handbook for defeating leftism. What I've done is to draw on what I have learned in 28 years of political activism. 28 years of beating up leftists, metaphorically speaking, of course, defeating them not only in the legislature, but also in daily life. Rules for Anti-Radicals. You might recognize that title as a play on Rules for Radicals, the book written by Saul Alinsky, which has, for 50 years, been the guidebook for leftists bent on taking over our media, our cultural institutions, and our schools. And judging by what's happening in today's America, they have largely succeeded. Whether or not you've heard of Alinsky, you feel the impact of his 13 Rules for Radicals every day in moral relativism, the claim that there is no objective right or wrong, in claims that somebody else's truth might be different than your truth, in advocacy media that lies or spins the truth to support the left's agenda because they believe that in pursuing their agenda, the end justifies the means. My book, Rules for Anti-Radicals, shows you how to counter that agenda, not just in the legislative arena, but in everyday life, whether it's at your kid's school, your neighborhood homeowners association, or even your place of work. And if you decide to get more involved with preserving American culture, Rules for Anti-Radicals can help you there as well, because the book is divided into 3 parts. Part 1 is called Boot Camp for Conservatives and is designed to help mainstream Americans defeat leftism in their daily lives. Part 2 is Activist Tools and Tactics and tells you how to get more involved in activism to preserve American values. And Part 3 is called Grassroots Organization and teaches even experienced political activists how to better defend those values. Again, the book is called Rules for Anti-Radicals, a practical handbook for defeating leftism. You can find the book on Amazon, of course, but if you order it directly from me, I will not only autograph the book, but I will also give you a discount on my upcoming online seminar called Winning Against Wokeism, Defeating Leftists in Daily Life. To order a copy of the book, go to rulesforantiradicals.com. Again, that's rulesforantiradicals.com. My name is Paul Vallone. You have been listening to Guns, Politics, and Freedom on the Big Talker Network at bigtalker.live, where each Saturday at 1 p.m., Sunday at 5 p.m., and weekdays at 11 a.m., we give you the ammunition to better defend your right to keep and bear arms. Please check out our sponsor, Hyatt Guns, America's largest gun shop, at hyattguns.com. You can also check out my website at gunspoliticsandfreedom.com, spell out the and, where you can find both my writings and earlier editions of the show. That's gunspoliticsandfreedom.com. See you next week.